Welcome to this Meaningful Use webinar with Thad Dixon. In just a few minutes, Thad will begin his presentation. But first, just a few things, which you probably all already know, but you're all currently muted, but Thad will be pausing on a regular basis to ask for questions. So if you want to ask a question, you can type it into the question box or click the hand icon next to your name, and that will alert us to take you off mute so that you can ask your question. We will send out the slides after the presentation. And just to let you know, this webinar is being recorded and it will be posted on the IMH website soon. And I'll send you a link to the recording when it's available. So here's that.
Well, hi, everyone. Thanks for taking time out of your day to join us here. And Shazana, can you see here our attendee list, how many we have on right now? I see 20. Is that what you see?
We have,
okay,
well, there's 18.
Okay, yes, that makes sense. Yep. Good. So that just gives me a sense of number of questions and people here. And again, thank you all for attending. As those of you who have attended before know, we have been conducting an ongoing series on meaningful use, electronic health record systems, technology, and sort of a variety of things encompassed by electronic health record systems with small counties in California. So today we're going to drill down into one of the core stage 1 meaningful use requirements and examine that particular requirement in a fair bit of depth and detail. This particular requirement is one that I'm sure many of you are familiar with and have conducted some level of risk analysis or audit around. So, you know, this is also an opportunity to discuss and share some experiences as I pause, you know, to have both questions and dialogue with the group here that may have been helpful for your practice, because this is ultimately a learning forum, and we want to share that information for those of you who may have already been down this road. So with that, let's go ahead and well, brief introduction for us. Most of you know who we are, but in the security vein, we are members of the International Information Systems Security Consortium and just recently credentialed with the Healthcare Information Security Systems Professional Credential. And we are also an Information Systems Audit and Control member and Health Information Management Systems Society member, and obviously work with small counties and other agencies around behavioral health and meaningful use. So with that, let's just talk quickly about what we're going to discuss today. And really the overview here and objective is to understand the requirements of HIPAA and high tech and to really look at how that relates to meaningful use, some implications specifically for the state of California, and ultimately how to protect the privacy and security of that information to protect our patients' rights as well as mitigate organizational risk. We're going to talk about the role of security audits and how it relates to meaningful use as well as certified electronic health record systems. And we're going to just distinguish between meaningful use security audits and organizational HIPAA compliance plans and policies and how those are related, but what are some of the additional measures that might be relevant? So one of the first places we start in determining what our obligations are under HIPAA is to discern whether or not we're a CE or a business associate. For, I would presume, every organization on the phone today, you are a CE, a covered entity. You probably already know that, and you probably already have HIPAA and compliance plans to some extent in your organization as well as policies and procedures. That said, because all of you have electronic health record systems, have a moving technology landscape, as all of us do in this industry, and also deal with business associates, there may be some additional factors that we discussed today that could be useful in your practice and in your own policy and procedure updates. So let's start with what HIPAA is and how to spell it. And I know most of us do know what it is. I often see it spelled wrong in the abbreviation at least, and it's a friendly reminder for me as much as anyone that it's HIPAA, Accountability Act, as opposed to HIPPA. And what that overall, of course, act specifies is that we protect privacy, we secure information, and we adhere to the minimum necessary standard. And that we have specific patients' rights that we have to adhere to for access, use, and disclosure. Now, HIPAA itself is actually quite old by regulatory standards, 1996 in fact. And so the implication of the additional regulations for HIPAA are significant because they have amended that original act and have significantly affected the way that organizations need to adhere to HIPAA related to electronic health information or electronic personal health information. So one of the main implications underneath the new regulations is how HIPAA High-Tech and the Omnibus Rule have affected the, or meaningful use High-Tech and Omnibus Rule have affected HIPAA. So essentially, there are, underneath the High-Tech Act, which gets to the meaningful use regulation and just a little bit of regulatory context, in 2009, the American Recovery and Reinvestment Act, or ARRA, had underneath it a provision called the High-Tech Act. And that is where the federal government placed the incentives for meaningful use. And with that, they also tied in an increased burden of regulatory compliance on a number of fronts, and one in particular, and the one we're speaking about today, has to do with security and privacy. And one of those additional requirements that was essentially added is that for organizations that are participating in meaningful use, there's a requirement to conduct or review a security risk analysis and to implement updates every year in most cases. And the annual requirement is related to the meaningful use reporting period. So because we're drilling down to this one measure, I don't have that on the slide, but let me just sort of review, as many of you may know, underneath the very first stage of meaningful use, which we're going to call Acquire, Implement, and Upgrade, or AIU. That's where you get the initial dollars for meaningful use participation. You don't have a reporting requirement. So for those of you who just panicked because you haven't done this yet, and yet you've received some amount of dollars, you have a little bit of time because there was not actually a reporting requirement underneath the Medicaid AIU provision. Now, in the next year of the program, which is when you're actually doing your 90-day meaningful use data requirements and collection requirements, that is where this security risk analysis component comes in. And I think it's probably obvious, but for those who aren't pursuing meaningful use, using an electronic health record system is, in my opinion at least, reason enough to still look at doing a security analysis of some type for your organization, a self-audit, regional extension center audit, or a third-party audit, to take inventory and look at your risk exposure. And these are some things that we're doing right now with CIMH, for example, because it is just, again, a part of managing that risk that we have all essentially have some exposure when we start to compile our information electronically, and we start to share that information, and we start to put that information on the laptops, phones, iPads, USB drives, and send it to exchanges or other locations. So what we have underneath these new requirements, or these additional requirements, and we'll remember section 13410D just for a moment because it is very relevant in a couple of slides. But we have a breach notification requirement which has been added. 60 days for breaches that have occurred. Once you've been aware of that breach, need to be reported to HHS. Now in California, you have an additional requirement under the CINA regulation, which we'll talk about in a moment. So the other thing that has happened is the fine and penalties for breaches have increased. Patients have some additional rights related to requesting electronic copies. We do see this in the meaningful use regulation related to patient portals and to personal health records or PHRs. We also have additional patient rights to restrict disclosure to healthcare plans for services that are self-paid. And we also have some mandates that business associates are directly liable for compliance with HIPAA provisions. So amidst all of the additional regulatory requirements that have come in underneath the new high-tech and omnibus regulations, which went into effect in September of 2013, you have, as a covered entity, again, probably all of the agencies on the phone right now, you have some additional protection, if you will, to at least transfer some liability to your business associates. And I know some of you have been in the process of updating BAAs, and I know that we provided some BAA templates for that to some of the counties. So that's an important element that we're going to drill into in a little bit. But again, that is part of something that helps you all because it, again, allows you to defer some liability or share some liability is probably the better way to put it with your business associates. And an example of a business associate, for example, would be our organization if we are working in a capacity with you in which we handle PHI or electronic protected health information. So you have many of those, and the vendors, of course, are often among that group. Okay, so in California, there are some additional requirements, and those are covered underneath the CINA or the Act, and that is California Civil Code. But again, it is intended to protect confidentiality of identifiable information. So we have here individuals and institutions that are relevant in this. Similar provisions that HIPAA contains, but an important note is that there is a 5-day reporting requirement for breach detection as opposed to the HHS standard. And underneath the Health and Human Services, or HHS standard, the breach reporting requirement is allowed to be superseded by state requirements if that is more strict and not in conflict with. And what that essentially means is that in California, you do have a higher threshold, or as it were, you have to report the breach quicker to CINA or via the CMIA requirement. So you also, within your own organizations, should have policies and procedures or be in the process of creating them that deal with how to report a breach, who you must report it to, and typically the privacy office within your own organization or the IT department if they are where your privacy and compliance office resides. They are who would typically be receiving that report, and we'll talk a little bit later about how that report gets filed. There's a lot of other additional privacy considerations, and there is ultimately only so much that we can cover at this point, but because we are a behavioral health and social services audience, it does bear mentioning that there's a number of other regulations and laws that are relevant, not just meaningful use and not just HIPAA. And that's why we talk, and you'll hear me say that this is really a global privacy and security strategy that we need to consider. And it's not just about HIPAA compliance or CINA compliance. It's about an organizational culture of compliance that takes into account a multitude of factors. We have a number of implications here, and these are mostly for your reference, and these slides will be distributed via PDF here post-presentation. But it is worth mentioning that obviously there is a CFR 42 Part 2 consideration for behavioral health, chemical dependency in particular at the federal level. There is also the Latterman-Pettis Short, or LPS, protection provision within California state law. And there are a number of payer requirements and contractual requirements that we all need to abide by. And it can be a bit overwhelming when one looks at all of those different regulations to figure out where to start and how to protect that information, especially as you enter into ever-changing environments of technology. And so we are going to try to provide some very succinct and concrete steps that you can take today to improve your organizational culture of security and compliance. And again, these are largely for your reference here. Along with the additional requirements, HHS has also offered some additional fines and penalties. And the civil penalties have increased pretty drastically for breach. And we now have up to $1.5 million in annual fines that can be levied against an organization for breach, and criminal penalties of up to $250,000, including imprisonment. In addition, there's state laws and licensure impact. And then, of course, organizations have themselves a need to have loss of privilege information and sanction policies. And one of the questions that I will ask here, and just for your consideration, is what are your organizational workforce sanction policies for privacy violations? And that is something that will come up later, because in case of an audit, there are typically going to be questions around what policies and procedures you have, as well as what your enforcement is of those policies and procedures for breach events. And all of this is related to the headlines we'd like to avoid, and to prove that HHS is serious, they frequently do levy fines, and state and federal agencies are not immune. Maybe breaches have been recently posted to the HHS Wall of Shame, as it is affectionately known, which is the public accounting of breaches that affected more than 500 individuals, which can be viewed on the HHS website. But a recent case illustrates the increased teeth, if you will, when HHS just about 15 months ago fined Signet $4.3 million for violations of the HIPAA privacy rule underneath the new high-tech increased threshold provisions, or the CMP provision, which is that particular clause that we mentioned earlier highlighted in red. And that is what allowed HHS to impose a civil penalty of $4.3 million, which is relatively significant by most accounts. And that is what Section 13410D does authorize, is that increased penalty. Now, if you read what it was that constituted such a large fine, and that is a very large fine, even by breach fine standards, you will see that there was a series of events which led to that. The most significant, I would say, in that, having read the court case, the civil case that resulted in that fine, is a repeated, Cigna repeatedly ignoring and failing to remediate the breach. So that right here, this is one of those cases, if you will, that the OCR is wanting to impress upon organizations. You need to report a breach and remediate a breach and take measures to avoid a future breach. That's the 1, 2, 3 or there will be repeated and persistent fines that increase. So with that, and let me take a pause here. We're going to move into patient rights, the next section, but let me take a pause here and see if there are any questions in the audience before we move to the next section. Okay, I'm not hearing any questions, so I'll assume we're all sufficiently concerned and have nothing to say right now. But we are going to address how to avoid being in those headlines, and that is really the point of this presentation, is the things we can do to avoid that. One of the things that, really is, that's the centerpiece of this is patient rights, and we are all patients at some point. So ultimately, this is about our own rights as much as it is about the patients that we care for. And so these regulations and rules, although with have some punitive measures, are ultimately about protecting our health information and our family's health information. So with patient rights come certain responsibilities, and as mentioned, I'll give a summary of these and then there's some detail after, but patients have a right to access and receive a copy of their own health information. So the protected health information comes in paper or electronic formats. It's ePHI if it's an electronic format. Some of you who are pursuing meaningful use may have ventured into portal territory, and that is an example of the meaningful use regulation essentially enforcing patients' right to obtain a copy of their own information. Of course, patients have a right to request amendments to that information if that information is incorrect. And they have a right to request restriction of the use and disclosure. And they have a right to restrict disclosure for self-paid services. And again, this is a recent change, but for services that are self-paid, patients have a right to restrict the distribution of that information. And then there is also a right to request alternative forms of communication and an accounting of the disclosures. So these are some of the updated patient rights. And the good news is that for those of you using certified electronic health record systems underneath the meaningful use regulation, and many of you are, if I would say most of you are using certified electronic health record systems, they do have functionality embedded in those systems that relate to these particular provisions. Whether or not an organization is using those is, of course, something that varies on a case-by-case basis. So there's a little more detail here, and again, this is for your reference. I won't trouble you with reading this, but there is 5 components of that and some more detail. But let's talk about what exactly constitutes protected health information, or PHI. So there are a number of different identifiers that constitute PHI, and it spans a very long frame of time as well. And in fact, potentially 150 years of time can be the span or duration of time, because it includes information about individuals who have been deceased less than 50 years. And it includes written, spoken, or electronic information, and it is information related to physical or mental health or condition. So ultimately, it is the information in your chart room, in your electronic health record system, and hopefully not on that USB stick rattling around the bottom of your suitcase. So the 18, as we call them, are the 18 identifiers, any one of which constitutes protected health information, i.e. non-de-identified data. So in order for data to be legally de-identified under the NIST standard, it must not contain any of these 18 components. And those are names, zip codes, dates, phone numbers, faxes, email addresses, social security numbers, even medical record ID numbers, health plan beneficiary numbers, Medicaid ID numbers could be considered a part of that. So do be aware of that. And I'll cite a particular example here. When you are calculating meaningful use volume requirements, for example, which is one of the requirements to establish eligibility in order to participate in the meaningful use program, you will oftentimes need to generate a report which identifies the Medicaid encounters and divide those by the total organizational encounters. And the Medicaid encounters are typically substantiated by a client ID and or a claim ID and put into a report. And at times, there will be a request for that information in some capacity to be even submitted to the meaningful use site. And one thing to be aware of is in the small print, you will see on the meaningful use site, which is the Medicaid Management Information System, or MMIS system, you will see small print that says, please do not upload any PHI. This site is not secure. And so one needs to be aware of not unintentionally committing a breach by uploading Medicaid ID numbers in a volume report to the state, even though they may ask for information to substantiate that. So that is one of those ironies of healthcare that we live in, is you may be asked for something that may not actually be good for you to distribute. And that is why we all need to adhere to ever-increasing levels of due diligence, because oftentimes the person asking for the information isn't aware themselves that they're asking you to breach information. So again, this list here consists of those 18 identifiers, even including IP address numbers that could be traceable back to the individual owner of that account. License plate numbers, certificate and license numbers. So there's a myriad of things, and we, again, refer to them as the 18. So if you have an electronic, let me pause actually right there before we move into the safety assurance component here. Do we have any questions?
Yeah, we have one that goes back a little ways.
Okay.
You mentioned no risk assessment prior to first year.
Yes. And so the question in particular then is?
I think just expand upon that.
Can I expand upon that? Sure. And that's actually a good question. And so there's a couple of things that we want to touch on there to just clarify what we mean by first year. Under the Medicaid program, there is a 6-year period. You start out in AIU, you move to stage 190, you move to stage 1, 365, you move to stage 2, 365, and then into stage 3. So those 6 years start out with AIU, and that is where you receive the $21,250 per eligible professional participating. And underneath that year, if your AIU year, for example, was 2012, you do not, underneath meaningful use at least, have to submit a security audit or any of the other core menu or CQM data points in order to qualify for that. Now, under the Medicaid second year, which is what we call the first year of actually meaningful use, which is when you're doing the 90-day reporting, that is where you now have the core, menu, and CQM measures, one of the core being a security audit that must be submitted, and it needs to be submitted related to the reporting period that you are qualifying for meaningful use. So that is essentially what I mean when I'm differentiating between a security assessment during AIU versus a security assessment during the stage 1 period. Does that help? Okay, Shoshana, are we okay to move on?
Yes. If he responds, then I will let you know.
Okay. Now, do I think that it is helpful to do a security audit regardless? Certainly. And again, we'll talk about some of the tools and the ways to do that. But let's first talk about the safety assurance factors for EHR resilience, or the SAFER initiative. This is information that you all can access, and there is a wealth of information at the ONC or Office of National Coordinator, and I do have some web URLs and links later in the presentation for you. And there's a lot of information on it, and so really we're just covering a couple of items to hopefully pique your interest to investigate some of these further. So for those of you who have an EHR, there are a number of different things that need to be considered, and there's a number of things that you can do. And I'm just going to offer 3 of them here, again, from the ONC HIT Security Assessment Toolkit program. And what I typically start with when we work with organizations on security and compliance is the overall culture of compliance, starting with the highest level decision makers and executive directors, to bring that group on board and into the security and privacy process. So this is something that I see a lot of organizations actually miss this step, and they roll out a staff training curriculum and a new employee training curriculum and policies and procedures for new staff to sign when they come on board, and all of that is great. But there is an important step to begin with, and that is that the entire management structure of the organization is a part of that and is a part of the educational curriculum as well as the advocate for this. So really, this entails educating decision makers on EHR safety, discussing implications for your organization. This, usually entails the IT department developing some materials or information or presentations that help educate higher level decision makers on some of the nuances of technology, on some of the risks of technology, and help put in front of CEOs and decision makers some of the tools and technologies that may need to be considered or employed in order to help keep that organization's data safe and avoid breach. Next thing that one can do is to ensure that information assets are protected using strong person authentication mechanisms. So this is where, if you are using a certified electronic health record system, and if you are using the RBAC component of that system, and that's an important and, that's the role-based authentication control piece, which is what will assign users to groups and groups to permissions and ensure that there are tiered and differentiated levels of access within the electronic health record system. And this is an area that we often see when we do system audits being underutilized. And I appreciate that it's often time-consuming to set up, but it is one of the inherent safety mechanisms within your EHRs that can be leveraged to, again, protect your patient's data. And what we do see, I would say, with quite a bit of frequency, are all of the users in the EHR being lumped into one group with the same security provisions and the same access. And so that's, again, a consideration. And, you know, with these, again, this is about a spectrum of compliance and a spectrum of safety. There is, you know, not any one thing, nor necessarily any one wrong thing that constitutes a failure of your overall security and compliance program, but there are things that we need to be proactively doing to move down that road of increased compliance. So implementing RBAC, that is one concrete thing you can do within your EHR. So, and this elaborates on that and talks a bit about, you know, separating clinicians, developers, training groups, DOs within that. And, you know, again, these mechanisms here, there is about 80 different safer mechanisms that are suggested on the HIT website. And I will give you that information later in the presentation and encourage you to go and check out some of those mechanisms. So before I move into some of the security components, do we have any questions on the electronic health record system? Yeah.
I have a question. If we did the security risk assessment in 2013, but are not demonstrating our first year of meaningful use until 2014, are we required to have another assessment? I thought we could use an existing report and take a few years to make the changes suggested. Please clarify.
Yes, excellent question, and that person is right in their assumption there, and that is that you need a security assessment under meaningful use that correlates to the year in which you're reporting on compliance. So, to say it another way, if you are skipping a year under meaningful use, you technically do not need to do a security assessment in the year in which you are not reporting to Medicaid for meaningful use. And the person who asked the question is also correct in stating that you do not need to necessarily do a completely new assessment every time. You can, oftentimes what organizations will do is a threat and vulnerability and overall risk, comprehensive risk assessment on year one, and then do a review and a remediation and an update report in year two and a year three, and then on the third year, or on the fourth year, I should say, do another full assessment. So full assessment, review, review, full assessment. So that is a way that you can certainly address that. And I think the key, and generally where we find that there are issues and findings related to the security audit component, is that there is an initial security audit done in year one, and then it is filed away and collects dust for 3 years, and the remediation recommendations are never implemented. And that tends to be the way that, or the component of security audits that end up getting organizations in trouble, as it were, underneath the meaningful use audits that are conducted by Figliozzi and Company, the firm that's been awarded the contract by CMS to audit for the use compliance. So great questions, and yes, you are right in your assumptions on that. And I think it's also worth mentioning that, you know, you can certainly, especially with appropriate segregation of duties, you can certainly do self-audit in the meantime. You know, if you used a third party to do your year one major audit, you could have a task team if they have appropriate segregation of duties, by that meaning that they're not the one person who's in charge of policies, procedures, passwords, building security, information IT, the servers, and also of auditing all of those things. So, you know, that's certainly a way to, again, perform a self-audit if you have a task force that you can assign to that. So with the security components, then, we have more than just technology, of course. We have people, we have information, we have technology, and we have facilities, all of which contain protected health information and potentially are areas that breaches can occur. Let's start with people, because we are ultimately the weak link in all of this. And I think that this goes back to the organizational culture of security and compliance. But ultimately, the best encryption will always be foiled by a yellow sticky note with a password taped to the bottom of the laptop. We do need to establish clear policies and procedures as well, and ensure that our staff and ourselves are trained to how to use strong passwords, and passphrases is really a better way to you know, educate staff, in my opinion, on that. You need to, of course, train by the role, and that's where your training curriculum should ultimately correlate to your role-based access control, or RBAC groups in your EHR, to maintain that thread of continuity and to have targeted training curriculums. You know, related training is, as I know you probably already do, obviously tracking the training, documenting the training, and ensuring that the organization keeps records on who received training and when is all very important. Starting at orientation and doing it again. That's another thing that, of course, is seen often, is people get a brief and harried introductory training, are thrown into the field, and then do not have an additional follow-up training ever. So putting that on a schedule and having some type of management or some type of system to manage your training frequency is very helpful for that. You know, monitoring user access or actions is also something that is helpful. So using logs, if you're using a certified electronic health record system, your system will contain user logs. But of course, there's also Active Directory access logs and other types of logging instruments inherent in Windows Server and in SQL, as well as third-party SIEM logging tools. So a number of ways to monitor actions are available. Dovetailing into information security, audit technologies or capabilities. Auditing, again, works, but only if it's used. I would suggest that organizations put into place a report that is run on a scheduled basis out of the EHR, which does log any activities and access and ensure that the access is appropriate and clinically necessary and minimum necessary. And your EHR is not the only system that should have logging. So if you have a wireless system, if you have other network or Citrix or authentication systems, if you have laptops, devices that may get on your networks that may or may not be approved, those are all areas that should have some level of logging and some level of scrutiny and accountability to essentially address and remediate. Facilities are the next component of infrastructure that needs to be controlled. Again, we have card key and role-based access. So the flaw, if you will, that we see in a lot of the facility security is that the card key system will allow access to the clinical room as well as the server room without applying a role to that. So again, we have a very similar protocol that can be used to access our facilities. Alarms, cameras can certainly complement those assets, or fixed security rather for those assets. You know, physical controls can compensate for a lack of controls on certain devices. So, you know, this is where, as many of you already do, you know, if you have a physical room that you can put your unencrypted or insecure items in and lock that room, you can then help gain security to a device that may not be inherently encrypted or secure. And then another technology solution we can use are asset tracking systems. So inventorying all assets, knowing which ones contain PHI, and being able to remotely wipe those assets and control those assets if they are stolen are important aspects of maintaining facilities and the contents thereof. All right, let me pause there. Any questions? Okay, so encryption is probably one of the best ways to mitigate breach underneath the safe harbor regulations of HIPAA. And the encryption can be done via both hardware or software mechanisms. And of course, it can be applied to any number of different devices. And you can employ both hardware and software encryption simultaneously. But those are basically, under the encryption and safe harbor regulations, the best mechanism to avoid a reportable breach, especially on the number one device that is likely to experience that breach, which is a laptop. So, you know, in order to look or to assess what it is that ultimately you need to be securing, this is where on the security assessment, you need to evaluate your software, your protocols, your physical settings, your access controls, your contracts with your business associates, as well as your patient relations and communications. So for the encryption piece, you know, there's some downsides to the encryption, and you know, it's not a magic bullet, but it is probably the best, you know, option that you have. You know, you do want to come up with a policy of how you encrypt both data at rest as well as data in motion. So data at rest being data on a laptop, data in motion being data sent from a laptop to a server, for example. And so, you know, I'm not sure how many of you may be using third-party or exchange tools, but there's a number of different systems out there that allow for exchange of PHI securely. Our organization uses Citrix, as do, you know, many others of our clients. There are a number of open source and free tools as well. You can use a 7-zip encryption for files, and you can encrypt those and then send those. But ultimately, one needs to understand the encryption and how it's working on the device, and probably best to coordinate with your IT department on encryption. One of the things that we do with our organization and recommend is utilizing hardware level encryption for laptops on the actual hard drive. So, for example, we recently replaced all of our legacy hard drives with encrypted, hardware level encrypted devices meeting the FIPS 140 compliance standard. That's the NIST encryption standard. And so the encryption, is at a hardware level much less likely to adversely affect device performance. For those of you who may have used TrueCrypt or BitLocker, which are two software-based encryption technologies, users will oftentimes experience a slowdown on their machines related to that encryption. The SSD is a hardware-level encryption, and we've seen very high performance out of those drives. And for not a huge capital investment, you can take an old laptop, you can add an encrypted hard drive, and you can achieve encryption without having to replace the entire device, and do it all for about $200. So that's a mechanism that we're fond of. As mentioned, it will not work if your users write the password on a yellow sticky note at the bottom of the machine. The most frequent way that a breach occurs, again, it will take 40 years to hack an AES 256-bit password with a computer, but 5 minutes to find it underneath the laptop if it's written there. So before we move into business associate agreements, any questions on encryption, laptops, and mitigating breaches under the safe harbor? Okay. So the BAAs are one of the best risk mitigation tools that you probably have as an organization right now to shift some of your liability to your vendors, and to really hold those vendors to the same levels of accountability and standard that you are. Now, at the end of the day, will it get you out of fine if your client's data is accidentally released by your business associate? That's something that is taken on a case-by-case basis. But what it does do is it increases the bar, the level of compliance and requirement that your business associates must adhere to, and it subjects the business associates to the same fines and makes them directly liable for those impermissible uses and disclosures. Another really important thing that having an updated BAA does for your organization, and by updated I mean a BAA that covers the high-tech and omnibus provisions that were put into place in September, as well as under the High-Tech Act, that allows you to, compel the business associate to report any breaches to you, and them failing to do so ultimately increases the likelihood that they will, and they alone will, be the ones that suffer the negative effects of failing to report a breach. Because if you did not know about the breach, you were not under a duty to report. So that's an important tool, if you will, in the BAA. So there are a number of, I think most of the counties received an updated BAA. Shoshana, did those go out to all of the small counties?
No.
Okay.
I think only the ones in the learning collaborative.
Okay. So there's a number of different templates available and out there, and Shoshana has some updated ones as well. So if you haven't yet updated your business associate agreement, it's a good thing to revisit. And like any instrument that could potentially be construed as a contract, we encourage all organizations to review with their own legal and compliance departments. But there are a number of different BAA templates out there, and HHS also has some on their site as well. So another thing that the new BAA framework does, which is worth mentioning, is that if your vendors use subcontractors, they also become covered underneath that BAA. And so in other words, the chain of liability does not get broken or deferred just because a business associate of yours employs or uses another subcontractor to perform some aspect of dealing with protected health information. So that is another important benefit that your organization sees underneath the new BAA construct. Okay, any questions on BAAs? Okay, so the risk analysis is the tool that organizations ultimately would use to help address or analyze their exposure to PHI. A lot of the information that we use to do risk assessments is covered underneath the NIST Special Publication 800-66. That is a National Institute of Standards document that you can certainly access and use within your own organization. And it starts with ultimately identifying and inventorying your assets that contain protected health information. So this is the first step that anyone will undertake to determine where your PHI is, how you receive it, how you create it, how you maintain it, or how you transmit it. And then also, as a part of that analysis, typically you would look at the external sources, where you get it from, and who you share it with, and human, natural, and environmental threats to information systems. One of the things that is worth mentioning here, I don't go into it in a lot of detail, but the contingency planning component of the security analysis is an important piece of the overall security and compliance puzzle. So in other words, what happens during a disaster to your information or to your service delivery is really an important component of your overall compliance plan. So if your EHR is offline, how do you continue to see patients? How is that information collected? And not just how is it collected, but now that your EHR is offline and you're potentially having to write things down on paper, how are you maintaining custody and managing security of that information that is being written down on paper during this period of disaster? And how is that data getting then back into the electronic health record system? And then how is that hard copy being disposed of? And ultimately, how do your policies and procedures specify that overall process? So that is something that, as we probably all have experienced, during implementation of our EHR, doesn't get a whole lot of attention. But as you move into your EHR being more stable and you using it on a daily basis, typically getting to the phase of a contingency plan, a disaster recovery plan, is a good thing to do sooner than later. So the risk analysis is, again, a component that is required under the meaningful use. And with that, there are some specific steps here. And I know that for those of you who have done meaningful use, you've probably been through this already. But for those who have not, ultimately, you need to conduct an accurate and thorough assessment of the risks and vulnerabilities. And there are a number of ways to do this. but this is governed by the NIST publication, and that is a public document available to any organization wanting to do that analysis. And obviously, there's a number of third parties that are out there that are perfectly happy to do that as well. So the questions, again, that we start with: how does your PHI flow? How do you consider with the bring your own device or BYOD policies? How do you deal with smartphones, tablets, and mobile devices within your organization? You know, those devices may well consume emails, and depending on what your policies and procedures and your server filters look like, those emails could have PHI in them, which could sneak onto a mobile device, which could sneak out the door, which could get left somewhere. So those are all chain of custody issues that organizations have to face or consider. And ultimately, putting your BYOD policies into written form and training your staff on how to use or not to use their cell phones or smartphones while on your premise is probably one of the best organizational ways to mitigate that risk. Another really important component of your security program is assigning a person to have responsibility of security. And this is, again, an area that we see, and Figliozzi and company has reported, as frequently missed within the security framework, is a failure to identify a specific person who is responsible for the development and implementation of the policies and procedures. And we find the best way to do that is to ensure that you update the job description of the person who is assigned that. So it's not enough just to tell that person that among their other many duties, they now are the security and compliance officer. It's important to actually reflect that in job description and to denote that in the organizational security plan. So the matrix or the risk assessment is one of the tools that can be used. There's about 80 different areas that typically will be analyzed. Those of you who have gone through the security audit have probably seen this or some variants on this form. We use this form and modify it for organizational type to ensure that we address nuances that might be specific to behavioral health, including specific CFR 42 Part 2 provisions that may be relevant for behavioral health versus other organizational types. But regardless of how you do it, the matrix, as we affectionately call it, is a good way to rank and assess where your organization is on the overall security spectrum. Okay, and we're just about ready to wrap up here, and I want to see if anyone has any questions here on that last section. Okay. For those who didn't attend or who may have just woken up, the way to report a breach, should it happen, is through the website here. Of course, that's something we'd all rather avoid. But as mentioned earlier, the breach reporting requirements do hold us all to a time-sensitive standard, both in the state of California as well as with HHS. And the form is available through this link to report that. And discerning within your organization how this process works is an important component of your security protocol. The incident response component, how you report a breach, who it goes to, what's the chain of command, and who's responsible for reporting that is a critical aspect of this component. And you will be met with a form that most people would rather not have to fill out, but it is a 3-page form that asks for a number of different pieces of information related to the breach type. One thing that I will mention is that when you are using encryption on a laptop, and this just happened to one of our clients literally 2 days ago. A laptop was stolen out of the car. The window was broken, and the laptop, which had PHI on it, was stolen out of the front. And that particular breach event represents 24% of all of the security breach events which happen. The stolen laptop is the most frequent mechanism by which PHI, presently at least, is breached. What's an important thing to consider with that type of event is that laptop happened to be encrypted. And in this organization's case, they were using a asset control system which allowed them to prove that that laptop was encrypted and thereby take advantage of the safe harbor exemption, as it were, under the breach and reporting requirements. So it is not enough just to have an encrypted laptop. You have to be able to prove that that laptop was encrypted. And if an auditor can cast a shadow of a doubt on your certainty as to whether or not that laptop was encrypted, they will not allow the safe harbor provision to be applied, and you will likely face a fine or penalty as if that data was unencrypted, and that would be a shame, because just purely for your lack of being able to prove it would be the event that caused the breach to be a reportable breach and a findable breach. And there's a recent case of this happening here, which sets precedent on this, related to a dentist office which received a $1.3 million breach for a laptop that they, quote unquote, thought might have been encrypted but couldn't prove. They are appealing that, but presently that is a fined breach. One more thing, and that is the video game that is available on the Health IT site, which I would say we could all go and play if it were up to me. But the HHS has on this link, and we'll distribute the PowerPoint or the PDF momentarily here, is an interactive video game that has been developed to walk you through some scenarios and essentially test some of the security constructs that we've just reviewed. And you gain points as you answer questions right, and you lose them as you miss the question. So it's a 10-week course, but you can take it in a day or less than that. And it provides a fun, interactive way to review some of the security provisions we've just gone over. So do we have any questions?
We have one question. How would you prove that a laptop was encrypted?
Great question. The official, well, let me put it this way. The best thing you can do is to document the process, the tool used to encrypt, use screenshots and or photographic evidence, and use a bootloader system that upon the laptop being started and being on the internet will send a signal. So there are some third-party software products that will send a message back to a central server. McAfee offers one that will essentially log the event post-theft. Think about it like a LoJack device. And in that, it can send a message back to that central asset control system. So typically, if you have a process for encrypting devices, which requires that a user fill out a form, sign a policy and procedure, or a use policy document, and provide some level of evidence to that, it will pass the muster. And one additional thing is typically you need to have some ability to prove that your encryption mechanism cannot be tampered with or overridden by your end users. And then there's one other piece, and that's that the key has to be not present on the device that was stolen. So, you know, when it comes to proving that, I typically sort of throw everything but the kitchen sink at it and say, you know, here's what we have done to ensure that this device is encrypted, and, you know, here's our proof of that, and that is something you want to be ready to show the auditor should they ask. Okay, any other questions on security or encryption?
Looks like it.
Okay, Shoshana, do you want to, I will certainly stay on if anyone is interested in talking here post webinar. And Shoshana, I don't know if it's best to take the parties off mute or what you'd like to do to kind of manage an open discussion forum, but I'm certainly available to stay around, as it were, in chat.
Yeah, if you would like to be unmuted, if you could click the hand icon next to your name, if that works, and then I'll know that you want to, rather than unmuting everyone. Anyone have anything for Thad? Anyone? I have not been able to attend the sessions 1 and 2 provided. Are they available online? 1 is, and 2 was actually not a webinar. It was a in-person meeting as part of the Finance Institute. For that
and
one,
I do have that presentation, although I do have that, Shoshana, so we could certainly post that.
I have the presentation, which just don't have a recording of it. Anyone else?
Okay, well, I want to thank everyone for attending, and certainly feel free to contact Shoshana or myself with any follow-up questions.
Hold on, Pat. There's a hand raised.
Okay.
Tammy, I'm going to unmute you. You did a code for your, in order to try doing that again. Sorry. can send any questions to me via email also.
Yes, that's certainly just fine, and please do so if there's any follow-up or questions or feedback, and we always appreciate your attendance as well as your feedback and suggestions for future webinars. So thank you again, everyone, for your time, and we look forward to announcing the date of our next presentation, which is going to be very close to a month away, and in fact, it's the 23rd of March, is that right, Shoshana?
24th.
24th, thank you.
And we'll out an announcement about that when we have more information. All right.
Great. Well, thank you, everyone. Shoshana, are you able to end the webinar and officially close it out? And
yeah, just I'm getting some questions about the PowerPoint, and yes, I will send out the PowerPoint to all of you who attended, and when it's available, I'll also send the link to the recording of this webinar. So yes, I can end it for everyone. Thank you very much, Thad.
Okay. Thank you, everyone. And Shoshana, you and I will speak soon. Thank you.
Okay. Goodbye.